What it do, what's up, people? And as you can see, I missed my flight, so my ass is still here in Dallas. But I want to do something a little different today because yes, I still have the videos. No, I have not finished editing them, and so I still want to give you guys something. And as usual, you are welcome to hit that donate button or link, Cash App, Venmo, Apple Pay, Zelle, and Google Pay. But however, I'm gonna make this quick because we're probably only gonna be on here about 10-15 minutes, maybe 20. But I'm gonna go a little deeper into the motion for discovery, because I've had a lot of people that I've spoken to, not just today or in the last couple of days or whatever, but in the last few months, and all of them having issue with discovery. The easy on that for me is the fact that with discovery, the one thing you have to do is be specific. And all of it is codified not only in federal law, but in state statutes, codes, and ordinances. Generally, you'll find it in whatever your state's organic code is. So, with that being said, I want to go here real quick and I appreciate anybody chiming in. That's always helpful. And as you come in, hit that like button, share it, do what you need to do. But here's what we're gonna do. All right. We're gonna go with what I tell everybody in your first 3 steps. When the first thing you need to do in your first 3 steps is 1, fire all bar card carrying attorneys if you're going to represent your own interests. That's the first thing. The second thing is write a motion for your entry of appearance. Why? Because everybody that's going into a courtroom to represent themselves or someone else need to have that, and you need to have that as well. Why? Because it's part of the process. So, and trust the process, and you don't have to be in Philly to do it. So the third thing is your motion for discovery. The motion for discovery must be 1, specific. Now, what I mean by that is you're going to ask for things that are directly related to you and each one of the elements of your matter. Now, to keep it kind of simple, when you file your motion of discovery and you enter your entry of appearance, in Georgia, they have 10 business days. So that's Monday through Friday. Those are 5 days. Any days after that, those days are logged on as just regular days. Saturday and Sunday is not counted, nor are holidays, but they have 10 days. The beautiful part of Georgia is they have 10 days once you enter the proper motions with your motion of discovery. And if your motion of discovery is written properly, whether you asked for it or not. So if you do your entry of appearance to let them know you're representing your own interests, that is proper enough to show them who they need to get the information to. Why? Because it is part of not only Brady v. Maryland, but it is a part of due process. And often in mine, because they're also a second step if they do not follow that. In a motion to compel, I always use the words good faith and clean hands, because again, those are words that are detrimental when it comes to law. Good faith, clean hands. Now, I'm going to use one of the actual Texas Code of Criminal Procedure 39.14, and that deals with discovery. Now, what I mean by being specific, there are certain things the DA cannot withhold from you. Now, basically those include offense records, any designated documents. So that will be your search warrant applications, anything of that nature. Papers, those will be things that are gathered as evidence, like chain of custody. Those are things that you will need or possibly need for a defense. Written or recorded statements of defendant, which would be, in your case, mostly if it's a criminal offense and you represent your own interests, it'll probably be you, or witnesses, including those made by law enforcement. That comes in with their police report, because you often hear them say, oh, well, I have to get your name for my report, because every time we make a stop, a report has to be generated. Yeah, they got to turn that over. Now, in most cases, they don't want to turn it over. I don't blame them, because you can't argue with yourself. And generally, they don't realize they're breaking the law or they're violating their oath, so they try not to turn those things over. Now, when you're also looking at designated books can be an array of things, because it could be something as simple as where evidence is stored, which would be DNA, things of that nature. Or it could be something as far as weapon inventory. Accounts, that will be if there was assets that were seized from you and were later set up. And evidence material to any involvement in the action or the crime. And when you're talking about evidence, the easy on that for me is everything that caused them to, quote unquote, say they had probable cause. That has to be turned over. Now, I kind of ran through that because that was the Texas code. Now, when you're writing up your discovery motion, one of the things I always do, I put in it, number one, any and all audio associated with the written citations. Because generally that's what they're doing. They're writing you a citation, and there's audio that goes with that. That can be something as simple as the 911 call to get them to the location, or the reason they're making the stop. Whatever it is, you have access to that audio. And you have it to include any and all communications made to or from any and all officers on the scene during the time of the stop. What happens is, a lot of times these officers have inner conversations. And what's up from Swanee? But they have inner conversations. In those conversations, that's where the chatter of, I believe it was two Roswell police officers, where they were actually literally flipping a coin if they were going to arrest somebody or not. And that was caught on their inner audio. Although they were sitting next to each other, they still had their mics on, which they recorded, which actually, because no one paid attention to it, got leaked to the defense. Defense then gave it to the media. That's when those two officers got fired. Why? Because the stop itself, in their case, was lawful. But the things that happened afterwards was on officer discretion, which left only the officers liable for their actions. And when you hear me say they are going to cover their own ass, the department, just because they wanted to cover their ass, they fired both officers. So that's what lets you know those things are essential when you're dealing with them. And then it would also include the call for the officer to report to the scene, the emergency call made to request police services, calls made and received by the officer during the first contact with the accused up until the finished transportation to hospital or booking. Now, what happens is, if you're going or transported to a hospital, you are generally going to be accompanied by one or more officers. They will all be talking on their walkie-talkies or whatever their little things are for communication. Those are getting recorded. You need access to that, because every little thing, while it may seem minute, those are the things that need to be asked for. And now, 2, any and all video associated with the above citations. Now, you often see these bastards with these body cameras on. Most of them do not keep them on, but they keep their dash cams running, because a lot of times you're out of the view of the dash cam. But what happens when you start requesting that? It's tending to show up that they are lying in their reports, because you remember I constantly say 76% of all video that is brought into court for or against a police officer do not come from police. 76% do not come from police. Do not come from police. 76%. 3 out of every 4 comes from a bystander and not police. But they want you to believe that they're the good guys. They're the ones to be trusted. But they're not turning over evidence to show that they are doing the right thing. So just keep that in mind. And then what you want are those cameras, the footage from that. Because again, those are essential to your defense. And 3, the application for the arrest warrant. Because 90% of the time, they're not going to have that. They're not even going to get the warrant until after you're in jail. And the one thing they cannot change is your time of incarceration, because that's why I tell everyone, if you are locked up, get a proof of incarceration. Say it one more time. Proof of incarceration. And the reason I say that is because I actually was smart enough, whenever I got locked up once, before I went back to go and sue the department, I sat there and argued with one of the officers to get a proof of incarceration. The reason why that became beneficial was because when it actually went into the computer, they said that I did not get locked up. And then I come out with this official stamped and certified proof of incarceration that the DeKalb County had given me. Now, who looks like they're lying? So when they're covering their ass, you need to do what you need to do to cover yours. You also want the arrest warrant. You want the search warrant application, which a lot of times is part of what we talked about yesterday. And in a video where I talked about the Hobbs Act, the young man stated, "Oh, well, I don't need your consent." Yeah, you do. Because he had no reason, nor did he articulate or point to a dangerous area. Those things are Terryville, Ohio. That is the simple. And a lot of times what you need to do is keep it that simple. Don't try to overlook it. Don't try to add anything to it. Don't listen to the extra sauce they're trying to put on it. You want your burger with cheese, and that's it. Lettuce and tomato, do what you do. Now, if you're allergic to tomatoes, you just want the lettuce. Just get it in. Yes, this is all part of the Brady request, because, again, that's a part of discovery. And you want an inventory log of all property from either the search of your person, the search of your property, or when you were incarcerated, you want a complete list of what was removed from your person. The reason that happens is because, again, that happened to me at DeKalb County. The problem was these dumbasses didn't even realize they took a picture of me with my jury on, but they handed it back to me without my jury. And then they tried to convince me that I did not have any jury when I came in. And I politely turned my wristband around, because they give you a little wristband. I said, "Well, what's that all on my damn neck and wrist?" Now, it took about 6 months for me to get compensated, but I got compensated for my stuff. But again, it's covering your own ass. Sometimes you have to be ready to sit your ass down a little bit longer to get the things that you need, because it's all about the fight. If you're not willing to fight, they're willing to take everything they can from you. And lastly, you want to make sure you have each officer's police. Let me back. You want to make sure you have each officer that was on the scene signed and filed police report from your incident, because that's where you look for discrepancies. You look for what's not in there, because this is where you don't even worry about your opinion. You don't even worry about your side, because they're not following law. That's the easy. If they're not following law and you're sticking to law, nobody cares about your side. Why? Because your side is them not following law. You having your if you go to the hospital, you get each and every hospital record. You get copies of what the EMTs. You get copies of who the EMTs were, what time they arrived, what procedures they did. You want a copy of all of that, because those things are relevant to your case. Now, if you run into one of those where you don't, or they don't want to turn those things over, just like we discussed in Brady v. Maryland. Oh, excuse me. Withholding evidence violates due process, which is why I talked about good faith, clean hands, because those are violation words. Those are phrases that are buzzwords. Where the evidence is material to either guilt or innocence, it has clearly been established that the prosecutors have an affirmative duty. What was it? I'm gonna read that one more time. It is clearly established. Remember we talked about it, clearly established? That's what the police don't. Clearly established that the prosecutors have an affirmative duty as a matter of constitutional law to disclose all exculpatory evidence to the accused in a criminal proceeding. They can't cherry pick. They can't determine what you should have and what you shouldn't have. They have to turn it over. They are the ones making the accusation. They have to be the ones that show proof. They are the only ones that have to show proof, not you. That's why your side doesn't matter, because you're not in defense. They are. They have to show that you did something. And then they have to convince 12 people to agree on you doing whatever it is they said you did. And if the prosecutor suppresses evidence favorable to the accused, it violates due process as guaranteed by the 14th Amendment of the United States Constitution. And now, just like we discussed in Youngblood versus, Youngblood v. West Virginia, 547 U.S. 867, and it's a 2006 case. Brady is violated when the government fails to turn over evidence that is known only to the police and their investigators. That lets you know they are still responsible for getting you that stuff, the information that I told you to be specific about, whether they have it or not. Because we know, you know, I know, the police aren't willing to turn that over. The prosecutor is still the one responsible for it, because the prosecutor is making the choice to cherry pick your case to push you into paying them money. I'm gonna say that one more time. The prosecutor is making a choice. Remember I talked about willful acts and ignorance? Those are the two things that cause them to lose qualified immunity. They're making a choice, because we talked about prosecutorial cherry picking. This is one of those instances, even if it deals with your case. Even if they don't have it, because the police don't want to turn it over, they're still responsible for it. And now, the last thing about that, going through all of that stuff, do you realize it still falls under the Freedom of Information Act? And you want to understand that the motion to compel, a lot of times you will hear it referred to as a Vaughn motion. The Vaughn motion refers to Vaughn v. Rosen. It is a 1973 case which discusses 1974 case which discusses disclosure actualities. These are the things that allow for clearly established for the prosecution. And when you're also going in, damn, I messed that up. You're also going in and you're understanding that the 1976 Government in the Sunshine Act is one of the things they try to use. But here's your defense to that. No record being requested is related to national defense. Your name is all over everything, so you're asking for your records. No record is solely related to the internal personnel rules and practices. Because regardless of what it is, it's part of a criminal case against you. You have the right to that. They have a duty to turn that over to you. So there are no personnel records. The record is directly accusing someone of a crime. While it doesn't directly accuse them of a crime, it may be used in a federal lawsuit later. So that's part of your evidence grabbing. Just keep that in mind. No record is information where disclosed would breach their privacy because the records being requested are of public record. Every time that they write a citation, every time they testify in court, every time they do one of these extra little things, they are creating a record that anybody can see. These are things that they also are required to turn over. No record will harm or delay the proceedings, and in fact could prove to speed this matter along to a conclusion where absent could serve to prolong them. Again, if I don't have means to defend myself, how can we actually have a means of going to somewhere where I need to defend myself? So again, these are the good guys. Why aren't they turning this information over? Why are they not helping you, allowing you to prepare to fight against them? Because it's not about law, it's about revenue. So if you feel like just giving them money, you going out there getting your hard earned for somebody else, keep doing what you're doing. If you're ready to stand up and fight and keep your money, keep your time, have them leave you alone, this is what you do. You have to stay focused on that. And then lastly, no record will lead to financial stipulation or endangering the stability of any lawful financial institution. Yeah, they're a financial institution, but it ain't lawful at this moment, so it is what it is. And keep that in mind. So you're not violating the 1970, okay, which is one thing we can rely on for police, government agents do not, for the people to employ some kind of policy within. Yeah, because they will try to withhold it. They'll do everything they can, but the problem is that walks them into the federal lawsuit, that walks you into a dismissal. But it only does that if you stay focused, stay on your line, and continue to press them. Because the best defense is a great offense. Ask Golden State, because they didn't have a very good defense, but their offense was hell. And they won a couple championships doing that. So the best defense is a great offense. When you start hitting, keep hitting. Back them in the corner, make them make a decision. So that's what I have for today. If you guys have any questions, leave them in the comments. You guys want to show some love, keep donations coming, hit one of the links. Well, they'll be up in a little bit, but just understand, when you're going for discovery, when you're writing a secondary motion to compel, you have to be specific. You stay on the line, and these are the things that you have that's codified that they have to turn over, and it has to be done in a certain time. And yes, you can request the officer. Hold on, because I should have had that in there. Because you know what? Because there is an actual case where I talked about you have the right to go after the person's character. That includes police officers, and the district attorney also has the obligation to turn over anything. That thing we talked about that with Brady cops. Any cop that has the tendency of lying on record or has lied before or been caught, the prosecution has to disclose that to you, and if they do not, that is a Brady violation as well. So yes, you do get those police records, but just know they probably won't turn it over, so you'll have to take a trip to the courthouse, and when that happens is you pull those records up anyway. So now I'm finna get my ass ready, so hopefully I can catch this new one and take my ass home. Love you guys. I'm working on it. You help out a lot with the short probation video. Okay, what could I do? It's been hit me on greatestnow@yahoo.com and we can set up a conversation, because like I said, I've been moving around, so it'll take me, hopefully tomorrow afternoon I'll be sitting down. So after 1 o'clock tomorrow I'll be sitting down and rested, and we can do some conversating and do all that good stuff. I hope you guys have been liking the live for the past couple nights. If you want me to continue doing more lives, just let me know. If I do lives, they're probably not going to appreciate it. They're probably not going to be like 15-20 minutes. I'm probably going to be doing them at least an hour, because I think that allows me more discussion time. It allows you guys to ask more questions, and it also allows us to become more interactive so we can get a better understanding. I'm still going to be posting the shorter videos where I'm giving it to you concise and all that good stuff. And I appreciate you, Blacklist. And keep doing live. I have a lot of okay. All right, we got 1 vote for live. I'll put the, matter of fact, when y'all go into community, I'm actually put a survey up, see what we got come up with. And then also, if you have a question or telling you when you got some yeah, actually I had an energy drink there. I ain't drink any coffee. But yeah, I appreciate you guys. Don't forget, hit that like button and hit one of them donation links. I love you guys. I'll see you mañana. Be on the lookout for the video, and also get ready to go to the community post probably tomorrow, and then we'll start posting some things, and hopefully you guys continue liking what I'm posting and have some direction for me. All right, bye.